The Korea Development Bank, KDB, has officially approved a debt workout program for Taeyong Engineering and Construction Company, which is grappling with the challenge of repaying around 9 billion won from project financing (PF) loans. In response, the Financial Creditor Committee of Taeyong E&C plans to temporarily suspend rights to claim all financial bond holdings. Instead, an external professional organization will be selected to evaluate Taeyong E&C's asset and liability status, along with the corporation's ability to continue, with the deadline set for April 11th. This marks a significant step in addressing the financial challenges faced by Taeyong E&C. Workout. Workout refers to a set of activities involving restructuring and management innovation aimed at facilitating the rehabilitation of insolvent corporations. In legal terms, it is often known as creditor groups common management, or simply, workout. This process is initiated to aid the rehabilitation of financially distressed corporations with the potential for recovery. It involves adjusting conditions, such as debt terms, with financial institutions or creditor groups holding bonds, evidence of loans, related to the troubled corporation. This proactive approach is taken before the initiation of any compulsory legal proceedings in court. When the workout process is initiated, various measures are undertaken to enhance the financial framework of the corporation. Examples of these strategies include elongating the maturity of short-term debts, establishing a grace period based on the financial condition and rehabilitation potential of the company, and minimizing interest rates and debt amounts. In South Korea, there have been notable instances of such restructuring efforts. In 1997, 7 Korean conglomerates, including Daewoo, were identified as subjects for the workout process under the International Monetary Fund (IMF) management system. Subsequently, a restructuring process was implemented for these entities. And recently, several affiliates of Kumho Asiana Group were selected as targets of the workout process and a restructuring process moved forward for them. Corporate rehabilitation. Conversely, corporate rehabilitation, akin to legal management, involves the appointment of a third party by the court to oversee the comprehensive activities of a corporation when it is burdened with substantial debts and struggles to manage them effectively. Simply put, this system aims to assist the corporation in rebuilding itself by reconciling the viewpoints of various stakeholders, including creditors and shareholders, particularly when the company faces bankruptcy but there is a perceived possibility of recovery. The decision to implement legal management is based on the judgment that preserving financially distressed corporations is more advantageous for the companies, creditors, and, on a broader scale, the national economy in the long run, as opposed to allowing them to declare bankruptcy. The primary distinction between corporate rehabilitation and the workout lies in the entity responsible for initiating the process. In the case of legal management or corporate rehabilitation, it is the corporation itself that petitions the court to explore rehabilitation methods. On the contrary, in the context of the workout, the initiators of the process are the creditors or financial institutions involved with the corporation. When a corporation applies for legal management, the court typically undergoes a 3-month evaluation process. Upon the execution of legal management, a court-appointed manager conducts a thorough investigation into the financial standing of the corporation. If it is determined that the company has potential for rehabilitation, indicated by a continuous value surpassing the liquidation value, the court mandates the submission of a rehabilitation plan. Once the court approves the rehabilitation plan, the formal process of corporate rehabilitation is officially initiated.